Hey everyone. Today I'll be speaking about the strongest possible policy interventions to stop the taxpayer subsidization of the buildout, combat corporate secrecy, and protect communities from the false promises of economic development of data center projects. I'll be covering both state and local policy interventions as tax incentives often span both jurisdictions. First, repealing and limiting tax incentives. While sales tax exemptions for data centers are typically granted at the state level, local jurisdictions may provide property tax abatements, which are full or partial reductions of property tax to data centers. Our strongest recommendations is to repeal any existing incentives offered by your locality and/or banning corporate tax subsidies for data centers. In the event that's not possible, we recommend limiting the incentive to the greatest extent feasible. This is especially important when it comes to tax abatements that would apply to schools. At minimum, localities should give school districts the power to opt out of any abatement for a negotiated duration and percentage. Local electeds and governments should also speak out against any state incentives as they take valuable resources away from communities they represent. For example, the Pima County Board of Supervisors voted to lobby against Arizona sales tax exemptions for data centers. For localities where data centers already exist, you can also aggressively tax data centers and their peripherals. For example, in 2025, Henrico County, Virginia passed a 550% tax increase on data center computers and related equipment. Next, we're going to go over a laundry list of possible limits on local tax incentives. First, they should be short-term, no longer than 3 years, and they should apply to no more than 50% of all taxable property. They should require local officials to commission an independent analysis of proposed incentives before granting any tax breaks. The study should be available to the public for a minimum of 90 days ahead of the incentive approval. They should require companies to abide by strong labor conditions. If the company pays a fee rather than taxes to the local jurisdiction, for example, payment in lieu of taxes, also known as pilots, demand that the revenue be invested directly into the community, including renewable energy infrastructure, broadband, or schools. Revenue generated from pilot agreements are also significantly less than they would be generated from full taxation. So make sure to take those sort of policy initiatives with caution. Localities should represent Localities should also report to the public the name and other financial and economic information about the subsidizing companies, the amount and the type of tax break each project is getting, the number of jobs created, the wages paid to the workers by type of job, as well as the total amount of property tax and local portion of sales tax abated for all projects. Next, we'll talk about repealing or limiting incentives at the state level. States should explicitly ban data centers from corporate subsidies and use tax exemptions, corporate income tax credits for investments or hiring, personal income tax diversions, and utility tax exemptions. States should also disqualify data centers from local property tax abatements, mileage rate preferences, and exemptions on power purchases. If these incentives do exist, consider conditioning the subsidy with a specific job quality standard and local hiring requirements. Note that data centers are not significant job creators, and so this will have a limited impact on the harms of data center expansion. States should also reject development of special economic zones that are designed to spur data centers. Special economic zones are geographic areas where corporations receive lucrative tax breaks in exchange for investment and in particular communities. In theory, these zones are intended to stimulate economic growth in depressed areas. In reality, these zones often lack community accountability measures, and the benefits rarely accrue to the residents of the community. When possible, states should proactively exempt data center development from existing special economic zone legislation. Next, we'll move on to transparency measures. Data center developers and operators often want to keep information about their deals secret. Strong oversight and transparency mechanisms ensure that data centers cannot hide critical information from the public. A particularly strong intervention is banning the use of non-disclosure agreements at both the local and state level. Non-disclosure agreements, or NDAs, are secrecy contracts signed between a data center developer and a local government that prohibit the government from sharing information about the development deal with the broader public. These are widely used. In Virginia, 25 out of 31 localities with data center projects had an NDA. Local governments can pass an ordinance prohibiting the city from entering into NDAs with data center developments. In some jurisdictions, you can consider a broader prohibition on NDAs in large economic development projects in general. Local governments can also approve formal policies preventing and restricting the use of NDAs and can institute sunshine periods that require public release of documents related to the development. One strong example, the Board of Trustees in Big Rapids, Michigan, approved a policy prohibiting employees and elected officials from signing NDAs around issues pertaining to public interest or taxpayer funding. States can also pass laws prohibiting localities from entering into NDAs with data center developers. A number of states have introduced legislation banning the use of NDAs in economic development projects. In addition to NDAs, there are additional transparency mechanisms available at the local level. This largely happens at the project approval process and local permitting processes. Pre-approval, you can specify minimum transparency requirements as part of the application process. Minimum requirements could include the value of tax abatements developers receiving for a project, the name of all the companies involved in a data center project, including developers, shell companies, data center operators, and financiers, a disclosure of jobs, short-term and permanent hiring efforts, and planned wages. You can disclose environmental impacts, power and water usage. For example, in Tucson, Arizona, they require all documents related to a data center project to be public for 90 days before any public meeting. You can also mandate public hearing, public notice, and community hearings. And you can reject proposals without adequate transparency measures. For example, commissioners in Moorville, North Carolina, refused to support a $30 billion data center project without knowing which company was behind it. Post-approval, you can require data centers to give monthly reports on data center water usage and electricity usage. You can establish mechanisms for continued community involvement, including a system of public reporting and a city response system to address community concerns. You can build out an enforcement mechanism to ensure that data centers abide by transparency requirements contingent upon approval. Jurisdictions must reserve the right to revoke conditional use permits or remove the certificate of occupancy if the conditions are not met. There are also other transparency mechanisms available at the state level. You can amend state transparency laws to ensure public disclosure. You can establish a statewide clearinghouse reporting monthly on water usage and energy usage of data center projects. You can fund these clearinghouses through charges to the owners and operators of data centers. You can also require statewide review of data center projects, track and evaluate interconnection requests, emissions, tax subsidies, jobs, and more. Finally, we're going to talk about common economic development policies. There are circumstances where your community might find it most strategic to be negotiating for labor or community benefits in the face of a data center development. As a goal, these recommendations to stop the data set. As the goal of these recommendations is to stop the data center build-out, we want to caution that we do not recommend these interventions as a starting point and believe that broader legislative and regulatory policies we discussed earlier will provide more comprehensive protection. But if these make sense in your context, including as an additional tool for leverage in your overall fight, here are measures to make sure these policies are effective harm mitigation tools. First, labor. A note of caution on work. As we've said before, data centers are not a significant job creator, and many of the promised jobs tend to be temporary or low quality. Establishing fair labor requirements could offset some of these harms, but would not address the underlying reality. Now, how do you establish these requirements? You can require data centers to hire full-time data center staff from the local population. You can require a living wage with benefits covering at least 50, with benefits such as covering at least 50% of the healthcare premium, adequate break time, strong health and safety standards, and reporting requirements about the jobs generated. In order to have these at the strongest level of enforcement, you should enshrine these demands into law. This can be done as part of the permitting approval process or conditioned as part of a tax break. State law, this can be enshrined in a state law or local ordinance. They can also be part of a legally binding community benefits agreement or CBA. Speaking of CBAs, CBAs are legally binding agreements traditionally negotiated between private parties, typically the developer of an industrial project and a representative of a community group. CBAs generally require that the community parties give up their opposition to the project, as well as give up their opposition to the project, as well as their legal rights to action in exchange for a set of developer commitments. To date, there is no successful public community benefits agreement for hyperscale data centers, and the scope and scale of the data center buildout has a key difference with other types of industrial projects where CVAs have been used in the past. The following recommendations are focused on where and how local governments can introduce policy guardrails to facilitate the CVA process in service of broader community participation from frontline communities. We won't go into all the specifics of what would make a stronger CVA here, but there are resources available. There are resources available in the chat from Better Data Center Project, Fair Shake Environmental Legal Services, Young Gifted and Green, and the NAACP. Many of these groups encourage CVO, local ordinances that require CVAs for certain types of developmental projects over CVAs alone. But if you are engaging in a CVA, you should ensure that the CVAs are legally binding, enforceable, and publicly disclosed. Binding commitments can be referenced as necessary conditions within the conditional use permitting process to give CVA stronger enforcement potential. You can also develop other tracking enforcement mechanisms with non-nominal penalties for violations. You should also make sure to prohibit the CVA process without metrics attached to full community participation and outreach. Ensure that community members who are most directly impacted by the effects of data center development, including air pollution or displacement, are the primary voices in negotiation. Establish and attach binding metrics to outreach and participation to ensure that all community members, not just those with existing connections with the government or developers, are able to meaningfully participate. Another option is to enable partial ownership or carried shares of profit provisions. If requested from frontline communities, it's possible to certify community stakeholders as partial owners of data center infrastructure and establish measures to mitigate community risk and liability, such as free equity or no interest loans. To close out, let's take a close look at how some of these apply to your state and locality. If you're interested in addressing local tax incentives, you should check if your locality is preempted from specific tax or subsidy regulation. Preemption occurs when a law at a higher level of government, usually the state, is used to overrule authority of a lower level. State law can be used to preempt local ordinances. Federal law can be used to preempt state or local law. For example, some states have tax incentive programs that automatically include property tax. Our recommended approach is that localities can pass an ordinance limiting or banning corporate tax subsidies for data centers, especially those restrictions that relate to local property tax or local sales tax. Localities can also use permitting and approval processes to demand transparency. At the state level, you should identify what state tax incentives apply to your data center, and then find out if your state is correctly disclosing and tracking those incentives. We advocate for an approach to repeal or ban. Our recommended approach is to advocate to repeal or ban these subsidies, push for disclosure of subsidy costs in your state, and ban the use of NDAs in economic development. And that's all for me today. Thank you so much.